And we are back with more on the Supreme Court rulings today. We were just talking about the presidential powers case, but there was also a significant decision about mail-in voting. So let's bring in CBS News chief Washington correspondent Major Garrett. And let's remind viewers that the decision was really against what the president has been talking about and what the president has been trying to limit in terms of mail-in voting. Major, bring us up to speed.
So the Constitution, Article 1, Section 4, establishes for states that they can determine the time, manner, and place of elections. That's in the Constitution, clearly written and delineated. And so in the state of Mississippi, the legislature decided to allow mail-in ballots, if postmarked or received within 5 days of Election Day, to be permissibly counted, if everything else about that voter registration and verification matches up. Meaning you're not going to hold voters responsible, not discount their vote just because through some vagary of the U.S. Postal Service, their ballot happened to arrive 5 days later. The Republican National Committee and other litigants challenged that. The Supreme Court said, no, that law does not violate the federal statute, which indicates that on Election Day, ballots should be received and counted. This is a state adaptation. 14 states in total have made that, so Mississippi and 13 others, where there is some grace period for mail-in ballots to arrive after Election Day and be counted. Essentially, the takeaway from this decision is the status quo holds. There will be no alteration to mail-in balloting procedures, timelines, and methods for the midterm election or any subsequent election unless Congress intervenes and changes existing law at the federal level to apply to all states. That is something President Trump is clearly pushing for, but there is resistance in the House and the Senate of varying degrees to that, and the legislative prospects for that Trump agenda item are pretty bleak. But the Supreme Court basically kept what exists in Mississippi and 13 other states on the books, and no alterations will be visited upon voters or, importantly, election officials between now and the midterms.
So, Major, you know this. The president has repeatedly argued, without any evidence, that mail-in voting and post-election day ballots counting undermine confidence in elections. I just saw him do an interview a couple of weeks ago in the wake of the elections in Los Angeles, where he argued and he ranted on about, Spencer Pratt and how the elections were rigged against him. And it doesn't appear, obviously, the court is not deciding today on the underlying principle of that. But I wonder if, for those people who support the president and who think about what the president says and take it to the bank, if today's ruling leaves room for Congress to change the laws, will this effectively settle the debate, at least as it regards mail-in voting around President Trump and some of his supporters?
Well, let's just remember, in 2024 and in 2016, President Trump won in jurisdictions that have mail-in balloting. The president himself votes by mail. Mm-hmm. Those are not, by definition, examples of anti-Republican voter fraud. The president won in jurisdictions that use mail-in balloting, that have grace periods after Election Day, and he did not challenge those results. Spencer Pratt, to your point about the Los Angeles mayor's race, is also not challenging the results in the LA mayor's race. He was in second place for a fairly good number of days after Election Day, but as ballots were counted, as is permissible under California law, that were legally cast before Election Day but arrived later, he lost ground and finished third, not qualifying in the 1 and 2 runoff system that California has. President Trump has questioned those results. Spencer Pratt, the candidate on the ballot, has not. And he's not going to litigate them. He understands how the system works. California has devised its system. Mississippi has devised it. 12 other jurisdictions, states, have grace periods for these mail-in balloting. Now, the president wants to severely limit that through the so-called Save America Act. He also wants to do other things about registration and citizenship. But again, that has a majority in the House. It does not have a majority of Senate Republicans, I don't think. We haven't tested that proposition, but it certainly doesn't have the 60 votes to overcome a Democratic filibuster in the Senate. So the president, though he is intent upon seeing that legislation passed, has no visible path to achieve that. That he continues to talk about it Yes, that's true. That is a rhetorical flourish of this particular presidency. It doesn't make it true. And I just remind people, President Trump has been elected and accepted results in presidential elections in which he voted by mail and millions of other Americans in those states voted by mail. And he never called those results fraudulent, only ones he disagrees with.
So, Major, the Republican National Committee is the one bringing this case. Tell us a bit about what we know about who votes by mail. I mean, we understand that more Democrats than Republicans tend to vote by mail, but is it much of a gap at all? You just talked about how the president won in states that do allow mail-in ballots to arrive after Election Day. What do we know about who this might impact?
It is evolving, as so much in America does. I will tell you this. In the early days, in the early advent of mail-in voting, it was a Republican initiative. Why? Because Republicans and those in their consultant class realized that people who might prefer to vote by mail had homes, residences, tended to be elderly, tended to be wealthier. They were doing other things and wanted the flexibility to vote by mail. In jurisdictions like Arizona and Florida in particular, Republicans were masterminds of encouraging and essentially making sure early mail-in balloting was done by Republicans. That's how they got early edges. It tended to be Democrats who voted on day of. That has shifted in the Trump era. More Republicans now tend to vote on the day of the election because President Trump has, for various reasons, few of them rooted in any facts, said there's something nefarious about voting on any day other than Election Day. Obviously, during the 2020 election, when many adaptations were made because of a global pandemic, remember, voting in person is a highly socialized process, so election workers had to be protected, voters themselves had to be protected. Mail-in balloting was authorized in lots of jurisdictions where it hadn't been before. That was a new thing. It was an adaptation, but it worked. There were safeguards in place, and the results were the results. They've been verified not once, not twice, but 3 times in many of those contested states. So there was a acid test, if you will, of mail-in balloting in 2020. Not everything worked perfectly, but it was an enormous and successful adaptation to deal with the global pandemic. Some jurisdictions have tightened some of those mail-in balloting since. Some have kept them where they are. But what the Constitution says about this is a state matter first. The federal government can apply rules to voting broadly, and it has. But it must honor the time, manner, and place dictates of the Constitution and defer to states when they develop their own adaptations. What the court said today was, this is Mississippi's adaptation, and it's permissible.